Hello and welcome to the Short Sale View. We're here today with Bryan and Memmott Law Firm to discuss some topics on short sales. So just tell us basically, what are some legal implications of a short sale?
That's a great question. It's probably the question we get asked most often. With short sale, there's several things that come into play. One is, does someone have any deficiency liability? In other words, when I'm done with the short sale, is the bank going to come and sue me for the difference? And other are taxable consequences of it. So when someone is deciding on what option they're going to take, they need to understand, first of all, do they have the deficiency liability? What are going to be the results of it? The other thing they need to really think about are the credit issues with a short sale. There are a lot of decisions and a lot of factors that are out there, and there is no one-size-fits-all solution. But short sale, for the vast majority of people that have to step away from their home, is going to be the best option for them. The reason why is a short sale is a lot better for your credit. Most people who do a short sale are going to be able to buy again within 1 to 2 years, versus with a short sale looking at, or with a foreclosure looking at 4 to 7 years to buy again.
Okay. And what are some issues like maybe with promissory notes? Are we seeing much of that?
Yes, you're seeing that with the short sale approval letter. A lot of times you see the lender say, we're going to release the lien, but we want you to sign a note for a part of the debt. And that's really critical, because if you are protected by Arizona law and you don't have the responsibility to pay that debt back, signing that promissory note will expose you to liability way beyond what you would have had in any other circumstance. For example, if you were to say, well, you know, if I walked away from this property and you were protected by Arizona law and the anti-deficiency statute, which Bryan will talk to you about in a few minutes, then you're signing away those rights, and you're extending your potential liability for the duration of that note, and that could be for up to 6 years or longer. So that's something you have to be very careful of. Now, in some instances, it can be beneficial. You have someone who may have, you know, $100,000 in debt, and they're saying, sign a promissory note for $20,000 over 10 years, and that person has deficiency liability, and they don't qualify for any protection, then maybe signing that note will be a way to facilitate the deal and help them and save them tens of thousands of dollars. But you have to be careful. You have to be very, very careful.
Good to know.
That's one of the benefits of the short sale as well. If someone has the deficiency liability, it can be a great way to settle it rather than wait for the bank to come back and sue you for the difference. You can settle it out at that point. And David talked about the deficiency. In most states, if someone sells a house for less than they owe, they're going to be sued for the difference. I mean, that's a pretty easy answer, right? I signed a contract for one amount and I didn't pay it back, so of course they can sue me for the difference. Arizona's different. We have what's called an anti-deficiency statute. Only 7 states have it. And it's really good in Arizona, and there are 4 criteria. If a person meets their criteria, then they cannot be sued for the deficiency. Criteria are pretty simple. First one is it has to be a residency, which means that someone lives there or has lived there at some point since I've owned the house. So it doesn't have to be my house. It can be an investment as long as someone has lived in it. The second part is it has to be 2.5 acres or less. The next one is it has to be a single family or a duplex. Condos can be single families as well, as long as they just own the one unit, not the whole complex. The last one is it has to be purchase money. Where people run into trouble, especially here in Arizona, is I bought my house and I refinanced, or I cashed out, or I got a home equity line of credit. All of those issues can make it so someone does not qualify for the anti-deficiency statute. But what people need to realize, or people need to remember, is the anti-deficiency statute is written to apply to foreclosures. Short sales are a lot better for people credit-wise, but that's why it's so important to work with someone who understands the issues, because it is not clear whether or not anti-deficiency is going to apply to short sales, and someone definitely doesn't want to be the test case. You know, especially within a short sale, you can make sure the paperwork says the right things that does release you from liability, or if you have a large liability like David was talking about, there's a chance for you again to settle that out instead of waiting to be sued.
And if I could just follow up on that a little bit, when Bryan talks about that purchase money, when you're thinking of a lot of folks who have those 80-20 loans, that purchase money comes into effect, and we're seeing it. We're seeing a lot of lenders trying to collect, even after foreclosures, on that 20% loan. You have to be very, very, very careful, because you are protected by the anti-deficiency statute on that, and people should be aware of those rights, and they should assert them and make sure that they aren't paying on something that they don't have to pay. And trust me, they will try to collect unless you tell them, no, they can't. As Bryan said, there are only 7 states with this statute, and most lenders deal in all 50. So it's something you have to be very, very careful of, whether you're signing a promissory note or you're agreeing to collection after a foreclosure.
Let me ask you a question. You touched on this. What about if that homeowner has taken out some money and maybe they fixed up their home, they put some improvements into their home? How does that qualify?
Well, there are two things that you have to consider for that. One, of course, is a deficiency issue, and there is, luckily for us in Arizona, a case that actually touches on that. And it says, if your loan is substantially or the majority purchase money, and I'll give you an example. You bought a house for $100,000. Then you did a refi, you got a new loan for $125,000, you took that $25,000 and you improved the house, you put in new countertops, redid your bathrooms, things like that. Can they sue you for that $25,000 that was not purchase money? Well, the courts in Arizona have said, no, they can't, because that loan keeps its purchase money character because it is majority purchase money. Now, that's the deficiency issue. The question comes up now with the tax issue. Are you taxable for that amount? Because we all know under the Mortgage Debt Forgiveness Act, which was the act that Congress took in December of 2007 to protect homeowners in cases of short sales and foreclosures from that tax on the deficiency, which Bryan spoke about, but we wanted to make sure that people understand there are two different things.
Sure.
The deficiency that you could be sued on and the deficiency that you can be taxed on. If that money is used in a principal residence for the improvement, purchase, or building of that residence, then, and the amount is under $2 million and that house is sold before December 31st, 2012, then you can exclude that deficiency or forgiven income from your taxes. And that's something that folks should be aware of. All of these things that we talk about require specific analysis. And I would not have someone say, well, you know, jeepers, I saw this video and I don't have to pay taxes. You should consult your CPA. You should consult your tax professional when you're dealing with these taxes. And we're not giving you every possible method of excluding this from this. So even if you don't fit under that statute, there may be several ways to exclude that forgiven debt beyond what we're talking about here today.
And the question we get a lot for the taxes, how does that debt show up? If I have a $300,000 home and it sells a short sale for foreclosure at $200,000, how that income is going to arrive to the homeowner is the lender's going to send them a 1099, usually a 1099-C. It's like a W-2 for independent contractors. And when that shows up, it's going to have to report it on the taxes as earned income. So congratulations, I just earned an extra $100,000 here. Of course, I haven't withheld anything, and that's a huge tax burden. And that's when you go into the analysis that David talked about. And most people can expect it. Again, that's the question we get a lot too: is are they going to send me the 1099? You have to plan on it. Most of them are going to send it, and so you need to be aware of it and understand how you're going to take care of it.
Good to know. One more question.